Thank you, everybody, for joining in. My name is Jeff Abramson. I'm a senior fellow at the Center for International Policy and also lead the Forum on the Arms Trade. The Forum on the Arms Trade is a network of experts around the globe. Our events are meant to give a chance for people to express different ideas and opinions. The forum itself does not take positions. My name is Jeff Abramson. I'm a senior fellow at the Center for International Policy and also lead the Forum on the Arms Trade. The Forum on the Arms Trade is a network of experts around the globe. Sorry about that. Meant to give a chance for people to express different ideas and opinions. The forum itself does not take positions. Sorry about that echo, everybody. Let me return here. And I just want to say that we're delighted to have you here. Obviously, we recognize that anytime you talk about the arms trade, it is difficult because there are actually lives on the line and security that matters. Especially in this situation, we recognize that people in Palestine and Israel are particularly concerned about what's going on. We want to recognize that there is suffering on all sides. The activities October the 7th were horrible, but the activities since then have also been horrible. What you'll hear from most of the panelists here is concern and critique about Israeli behavior. As many of you know, most of the weapons being provided are being provided from Israel, especially from the West. But this is a platform for opinions. They might not all be your opinions, but please be respectful of each other. And in terms of technology, everyone, audience members should be able to use the chat to talk with each other, but please put your questions in the Q&A. And this is all you're going to hear from me. I'm going to turn it over to Valentina Azarova, who's going to be our moderator. Thank you so much.
Thank you, Jeff, and hi, everyone. I'm very glad to be here to facilitate this conversation with 4 panelists, which we'll hear from very shortly. I'm a scholar activist working on and against the violence of law and legal systems, including their role in enabling and reproducing violence through the arms trade and militarism. Most relevantly, I'm a founder and member of the Emergent Justice Collective, which is one of the groups that co-created the Arms Trade Litigation Monitor, together with Safer World and supported by the International Commission of Jurists. And the Monitor has, since around 2018, when we organized the community of practice, of practitioners, advocates, and groups involved in challenges against arms transfers, has monitored the domestic proceedings and other legal interventions that have taken place since the entry into force of the Arms Trade Treaty. And it is also looking at the various efforts that are being undertaken in the context of the ongoing genocidal violence in Israel-Palestine. Our purpose really was to look at the ways in which the international and national laws limit efforts to challenge and contest the international arms trade, and also, of course, to uplift the legal struggles and counter narratives that are being formed by this community of practice, members of which, of course, are amongst you and on the panel. And we're going to hear from them about the ongoing efforts they're involved in a minute. I will also say that for those of us at the Emergent Justice Collective, this work is part of a commitment to centering systemic, intersectional, and decolonial transformative justice and accountability in response to mass and structural international violence, which, as many of you know, has in most part not been available through existing justice systems, whether domestic or international, which focus on carceral and punitive justice that often reproduces violence. But I'm gladly here not to speak any further, but to facilitate this forum, the purpose of which is to map and situate some of the ongoing legal struggles in relation to Israel-Palestine and the arms trade, and more broadly, conflict-related accountability based on international and domestic law, and hopefully to allow you to gain a bit more understanding of the prospects and limits of these different legal avenues that are being pursued to challenge arms transfers in particular, and their context more generally as a response to international violence, through the international system and in the context, or let's say against the backdrop of the International Court of Justice proceedings on the genocidal violence taking place in Palestine and Israel. So we will start now with our two first set of interventions on the International Court of Justice proceedings and the ways in which those interact and relate to some of the ongoing attempts to challenge arms transfers to Israel by Shahid of Kent Law School, Shahid Hamouri, and Katie Gallagher from the Center for Constitutional Rights. And then we will move on to two further panelists, and I'll come back to you before that. So Shahid, may you take the floor if you're with us, and maybe you could start with an introduction of yourself beyond what I've said, just to situate your work as well.
Thank you. Just a thumbs up, you can hear me? Okay, thank you so much for having me today. And I join you in multiple hats that I wear. First of all, as noted by Valentina, I am a lecturer in international law at the University of Kent. I am also an resident fellow at Al-Haq organization, which is based in Ramallah, Palestine. And I'm also currently a researcher working on the arms trade. So I'm finalizing a book on corporate war profiteering in international law. And ever since the start of the current onslaught and genocidal violence, I have been coordinating a central working group in relation to arms accountability. As noted by Valentina, what I'll be doing is trying to center some of the international legal perspectives in relation to arms accountability. Most notably, how has the current case at the International Court of Justice changed the dynamics? As you're all well aware, South Africa has instated proceedings against Israel under the Genocide Convention. The idea behind the Genocide Convention is the prevention of genocide, and at this point, we're looking into provisional measures in order to prevent and stop genocide. So what was needed at this stage of the proceedings was to prove that there is a risk that genocide might be happening and that the Genocide Convention is in action. And during the pleadings, whether written or oral, South Africa has made multiple references to the use of heavy weapons by Israel. A good part of them, like 155 millimeter shells that weigh thousands of kilograms, are considered to be de facto, the usage of them is considered to be a de facto war crime in densely populated areas. We've also seen the use of new weaponry and the emergence of, let's say, a very much wider variety of harm that could be done by new weaponry. So the usage of such weaponry is also used as a part of proving the genocidal intent of Israel in the current onslaught. So the hope coming out of the case is that we enact the Genocide Convention. What does that mean? It means that all states in the world recognize that we are at a risk of imminent targeting of these people, and that risk becomes something that enacts a wide set of legal obligations at hand. So a part of the provisional measures, of course, is something that is currently very important to us, which is the preservation of evidence, and that will be one of the biggest problems in future litigation. Thus far, we've had a very big problem in trying to document and ensure that we need the evidence, specifically by linking specific weapons used to specific attacks, and in this case. And this is very important if we are to ensure rightful accountability for the Palestinian people. Further, we're also looking at the instatement of the duty to prevent by all states. That means that we all recognize that genocide is happening, and all legal systems around the world have to adapt to that. And I will elaborate on how that relates to arms litigation in a little while. However, if Israel does not abide by the provisional measures, if the ruling of the court is positive towards the South African argument, then we are looking towards going back to UN mechanisms, including the Security Council and the General Assembly. We have precedents specifically actually in relation to apartheid South Africa, where political unwillingness, let's say, to enact international legal obligations had meant that the General Assembly hurried to issue mass arms embargoes. It's very unlikely that we will see that coming out of the Security Council, given the US veto. But with the General Assembly, that means bit by bit further alienation for parties that dismiss international humanitarian law, but also a mass call for sanctions and embargoes. And that is the first step in what seems to be a longer issue in terms of stopping the arms trade in the context of grave illegalities. So further, if the court finds that we are within the remits of the Genocide Convention, states also have the duty not to recognize this illegality, not to cooperate with this illegality on top of their duty to prevent genocide. The first two duties that I said are already somewhat existent in relation to the overall occupation of Palestine. We must also remember that there was a prior case in 2004 on the wall that was built by Israel within the occupied Palestinian territories, where the court found that Israel is in contravention to its international legal obligations and asked states not to recognize this illegality, and also asked states not to cooperate in enabling this illegality. We also must recognize that there is another ongoing parallel case that is an advisory opinion in relation to the illegality of the Israeli occupation as a whole. The oral pleadings for that is in February. So we might also then again see let's say, further positions by the International Court of Justice in relation to state obligations not to recognize or cooperate. So what this means is, and coming from the highest court of law in the world, is that it will open up spaces for litigation when we are trying to take things forward in national courts. I will elaborate later on some of the ongoing efforts nationally. However, in this case, what a decision by the court means is that, one, foreseeability that the trade of arms will lead to violations is there, and foreseeability of complicity as well as fault is there. So it will somewhat ease litigation. I will continue. Sorry, I will finish in a second. It will somewhat ease litigation for us in the future, taking it forward that corporations and state both can argue that in this case it was foreseeable that this trade will contribute to and benefit from violations of international law. And I will expand further on this in the next segment. Thank you.
Thanks, Shahid. Katie, are you with us? And could you take on a bit of discussion situating the international law proceedings and perhaps also speaking about the US case, which you're involved in, any other efforts, legal advocacy?
Sure. Well, thank you. And really thank you for convening this very important discussion today. And I think especially at this juncture, even before the International Court of Justice's hearings last week and the very important and extremely comprehensive application filed by South Africa on December 29th, I think we already had a basis for states to act and for corporations and those who are providing arms in this unfolding genocide to be on notice that their actions were in contravention of international obligations. And so for me, as an attorney at the Center for Constitutional Rights in the United States, an organization that engages in litigation, advocacy, and public education, when we saw already on those first days after October 7th, statements by senior Israeli officials. And here I'm talking about the president, the prime minister, the minister of defense, the minister of energy, not low-level people, not mere rhetorical statements on the side, but the leadership of Israel expressing what was clearly, unfortunately and shockingly, genocidal intent. We were looking to see how the United States would respond. These senior Israeli leaders promised to unleash a military assault on Gaza like it has never seen. And I think in saying that, we need to remember what was already happening in Gaza on October 6th. It had been subjected to decades of prolonged belligerent occupation, a 17-year closure denying basic fundamental rights to the 2.2 million Palestinians there, and continual military assaults, with Operation Cast Lead in 2009, another assault in 2012, in 2014, attack on the Great March of Return in 2018, attacks in 2021. And Israel was promising something more than those horrific, devastating military assaults and the harms from the closure. So Israel was announcing that it was going to unleash a campaign of killing, of serious bodily or mental harm. And as the Minister of Defense and Minister of Electricity promised, no food, no fuel, no electricity, and no water for the Palestinian population, a total siege. And when you look at what genocide is as a legal concept, it is that intention to destroy in whole or in part a group based on their identity, including nationality or ethnicity. And that group, in whole or in part, can be in a geographic area. The underlying acts, one of them that is so resonant in what we've seen by Israel, with, we'll talk about support of a number of countries, most notably the United States, of course, is the creation of these conditions of life to destroy the population in whole or in part. So as Israel has denied basic necessities, including medicine, and made that announcement and then followed up with action, what we've seen the President of the United States, Joe Biden, Secretary of State Blinken, Secretary of Defense Austin, what we've seen them do from that first week of October through the present is to continue to promise Israel all measures of support it needs for its campaign. And so the United States, having already provided $3.8 billion of military support to Israel, and having in place in Israel a $4.4 billion estimated stockpile of weapons, it promised to provide even more weapons and support. And we've seen not just promises, but actions. The United States has provided further munitions, having done so in October, and again, over the course of many months. These 3 months, it's provided the JDAMs, which are known as dumb bombs. These are inherently indiscriminate and incredibly harmful in their effects in terms of even the wave and the not only the physical destruction, but the impact of the use of these bombs. The United States, on a day when the Security Council was trying to get in place a ceasefire resolution on December 8th, not only did the United States veto that ceasefire resolution, but again, the next day, it provided another $150 million worth of weapons with no conditions, no red lines. So this provision of military support, this continual provision of diplomatic support and cover, with the knowledge of Israel's genocidal campaign, both the intent and the actions, we could say that the United States is complicit in genocide. It is certainly complicit in the international crimes being committed by genocide. And as we heard already, the obligation to prevent genocide is one that exists on all states, and that obligation kicks in the moment a state is put on notice of the serious risk of genocide, and that obligation to prevent is heightened when a country has the ability to influence a potential genocidal actor. So here, for the United States, everything I described in terms of the support that has been given is an absolute contravention of the United States obligation to prevent genocide, and has, I would argue, moved over to actual aiding and abetting or complicity. So at CCR, at the Center for Constitutional Rights, as we saw this evidence growing already in October, we put together a legal and factual briefing paper warning of the way these facts showed a breach of obligations of the duty to prevent and risked a crossover into aiding and abetting or complicity in genocide. We sent that briefing paper to President Biden, Secretary of State Blinken, to the US Ambassador to the UN. And the very day that we delivered that to the US Ambassador to the UN, again, there was another veto of a ceasefire resolution. So not seeing the United States change course when it was warned of its breach of obligations on November 13th on behalf of the Palestinian human rights organizations Defense for Children International, Palestine, and halt, as well as 3 Palestinians from Gaza. And I can tell you it's a very difficult thing to try and be filing a lawsuit at a moment when, as plaintiffs, you are not able to communicate normally with the outside world, but tremendous respect for our plaintiffs from Gaza. And then also 5 Palestinian American plaintiffs who have family in Gaza. In that lawsuit, we asked the court to find that the United States was in breach of its obligations of the duty to prevent genocide and was complicit in genocide. And we have asked the court, in addition to making declarations of those legal findings, to enjoin the United States from further providing support for Israel's genocide. Very similar to the provisional measures that are sought by South Africa against Israel at the ICJ. The United States has contested the case, largely on technical legal grounds rather than factually. And next Friday, on January 26th, we will be in court in California against the United States Department of Justice, trying to have our case proceed and to get these preliminary measures, this preliminary injunction in place to try and stop this genocide.
Thanks, Katie. There were some questions that were very specific to the interventions we just heard. I will suggest that we take those up once we're done with the next 2 interventions, if that's okay. And our next 2 interventions focus on legal efforts to challenge arms transfers before domestic courts, including the US case. Frank Slijper from the Dutch NGO Pax will speak about the Dutch proceedings, and John Raming-Chappell from the US-based Civic will speak to the US court case and other non-judicial avenues for accountability for arms transfers. Frank, if you want to also further introduce yourself, the floor is yours.
Yes, hello, good day. Thank you for having me here. And indeed, my name is Frank Slijper. I work for the Dutch peace organization PAX, where I do research and advocacy on arms export control, as I've done for the past 30 years. And maybe before I go into this specific court case that we started a month and a half ago, I'll give you a little bit of background to maybe understand the case a little bit better. Since 2002, the Netherlands is part of the international F-35, also known as Joint Strike Fighter or Lightning II program. which is run by the US Pentagon, and with Lockheed Martin being the main contractor of the fighter jet, with a few other big suppliers of subsystems, but also probably hundreds of smaller subcontractors from across the globe. That is to say, from countries that have bought the F-35. And these include a couple of dozen Dutch companies. And besides producing bits and pieces for the F-35, one of the biggest deals from the side of the Netherlands was that it won a contract to set up a logistical hub at one of its Air Force bases called the European Regional Warehouse, from where spare parts and components are supplied to wherever needed in Europe, as well as Israel. And there are only two other such hubs, one in Australia and the other one in the US. And to enable smooth operations, smooth transfers, the Netherlands introduced in 2016 a so-called general license for the F-35, which ensures that companies, once they're certified for that general license, can export anything F-35 related to anywhere where it's needed. So these companies don't have the hassle that normally goes with individual arms export licenses, where a government official has to assess a license for every single export. This particular F-35 general license actually does not even outline any period of time for which it's valid, nor for a specific range of destinations. It's simply an open-ended license for any F-35 transfer from the Netherlands. So with this background, fast forward to 7 November 2023, when a Dutch newspaper called NRC reported an explosive story that the Dutch government, despite questions and warnings from within the government, had decided to continue, to allow and continue with emergency transfers of F-35 components to Israel, which had been ordered right after the terrible attacks by Hamas on the 7th of October. And it turned out, as we know from a memo that was released by the Ministry of Foreign Affairs, that the Dutch government decided to go ahead despite recognizing risks of F-35s contributing to war crimes, because the Dutch government considered the risk of damaging its relations with the US and Israel more important and overriding the risk of contributing to violations of international law. With the knowledge of what happened in the month after the attacks of 7 October, 3 Dutch NGOs, PAX, my organization, as well as Oxfam Novib, the Dutch branch of Oxfam, and the Rights Forum, a Dutch organization focused on Palestinian rights, immediately decided to start launching a civil suit against the government, demanding an immediate stop of transfers of F-35 components to Israel, as we claim that these are directly in violation of obligations by the Dutch government under both the EU Common Position on Arms Exports as well as the Arms Trade Treaty, but also violating obligations under the Geneva Conventions and the Genocide Convention. Within a month, on 4 December, we had our hearing in the court. 11 days later, the court decided against us. The court recognized a few important points in our favor. One, that we had legal standing, which before had been an issue. And second, that we were right to assume that the risk of F-35s contributing to war crimes was real. However, the judge also ruled that the government has far-reaching freedoms in the area of foreign policy, and also that the government, when reassessing the transfers of F-35 components to Israel, was right to take into account other concerns, such as damage to its diplomatic relations with Israel and the US, as well as the financial economic consequences of stopping part of the transfers, including the reputational risk that the Netherlands would not be seen as a trustworthy business partner. For us, this was, of course, clearly unacceptable because, in our view, it is one of the clearest examples where you would expect export control policies and treaties make a difference. That is, to stop arms exports when human rights are severely at risk. Moreover, in the case of individual arms export licenses, the Netherlands has shown a rather restrictive policy for Israel, where mostly a few relatively small export licenses have been granted over the years for Israel, and quite a number of export licenses have indeed been denied over the past years. So if Israel's war in Gaza would not trigger a stop on arms transfers, then what would ever? Therefore, we appealed the court's decision, and next Monday we will be in the court again. Of course, we've seen in earlier cases in the Netherlands as well as internationally, for example, in the context of Yemen, where despite all the horrors happening, governments nor courts saw sufficient reason to stop arms exports. But we're hopeful this time, and despite the loss earlier in December, we think we have a good chance next week. The whole world sees what's happening to the people in Gaza, how especially fighter aircraft have bombed so heavily. How on earth can you then continue exporting weapons that so clearly play a role in the conflict? Of course, a minor concern, but where the Dutch government is obsessed with damaging its reputation vis-à-vis the US and Israel, it apparently does not care how its reputation in the rest of the world has been damaged. I'll leave it here for now. Happy to answer any questions later on. Thank you.
Thank you, Frank. John, the floor is yours. We're looking to hear from you about the US case and any other legal advocacy efforts, as well as any further comment you'd like to make on the ICJ proceedings, which I know that you've also been following. And
Thank you so much.
A minute to introduce yourself as well.
Thanks so much, Valentina. I really appreciate it. Sorry for being a bit late, just coming back from a congressional briefing. My name's John Ryman-Chappell. I'm an advocacy and legal fellow at the Center for Civilians in Conflict. I focused on civilian harm, human rights, security assistance, and arms sales from specifically US law and policy, also international law as relevant. I'm a US lawyer. I'm going to do my best to speak for a general audience because I suspect that we have a very diverse group of attendees today. A piece of context, I'm not a litigator, so I don't show up in courtrooms. I work primarily on policy, and so I can't speak with the same courtroom experience that some others on this call might be able to. And I'm going to speak specifically about US legal provisions that are related and relevant to the US supply of arms to Israel now. I think that that's appropriate partly because of how many weapons the US government is sending, the consequences that those arms transfers have. And while certainly we've seen horrific actions by Hamas, the United States does not arm Hamas. And so I'll be drawing from some publications I've had in the last couple of years that deal with questions about US law and policy related to arms transfers and their enforcement, difficulties with judicial enforcement and other pathways that are open legislatively. So to start off with some of the most relevant law and policy, in the United States, the Leahy laws, which might be familiar to some, prohibit the provision of security assistance to any unit of foreign security forces where the US government has information, credible information, that they have engaged in a gross violation of human rights, which is a defined term in another provision of law. There's also Section 620I of the Foreign Assistance Act in the United States, which prohibits security assistance to any country that has, and I'm paraphrasing here, restricted the delivery of US humanitarian aid. Section 502B of that same act, the Foreign Assistance Act, prohibits security assistance to any country, the government of which engages in a gross violation of internationally recognized human rights. There's also in the Arms Export Control Act, certain enumerated approved purposes for the provision of US weapons under that act, and violations of human rights or international humanitarian law, as you might expect, are not among the approved purposes. And I'll also talk about policy for a moment. The conventional arms transfer policy that the Biden administration released earlier this year, or early last year, now we're in 2024, says that the United States government will not transfer weapons when it is more likely than not that those weapons will be used to commit, facilitate, or aggravate the commission of serious violations of international human rights law, humanitarian law. So we have all these standards, right? US law is not silent when it comes to the provision of weapons and other security assistance when they raise human rights concerns. Why is it that courts have typically not been amenable to the enforcement of some of these provisions? That's basically the question that I want to ask, a question that I have asked in some past publications. And the first thing to bring up is that when it comes to policy, it's typically unenforceable. So that conventional arms transfer policy, that more likely than not standard that I mentioned just a second ago, that has a line in it that says that this is not legally enforceable. Essentially, this is not law. So we can cut out the various policy provisions because they've been formulated in ways that makes it so that they won't be enforced in a courtroom setting. Then there are laws that are constructed in ways that make enforcement difficult, and also that open up to interpretations by US government lawyers that allow maximal flexibility. So some of those are little clauses like when the Secretary of State has credible information, or when the US government determines. So you have standards that are put into law, but you don't have but you have deference to the executive branch about how those standards are actually implemented. And so that deference also shows up in US case law. And so there's a Supreme Court case, US v. Curtis Wright, which is an arms manufacturer. It's a 1936 case, and this arms manufacturer was selling military planes to Bolivia, and that was during the Chaco War. It was in violation of essentially a US government embargo. And it gives rise to this theory of foreign affairs in law where the president is described as the sole organ. That's based on a quote from Chief Justice of the Supreme Court, John Marshall. It's kind of had a very extensive afterlife. There's been a lot of criticism of this decision for overreading the president's role and underemphasizing Congress's oversight. But unfortunately, it's had a lot of sway and has led to quite a bit of deference by many courts to executive power. The other thing that I want to talk about in my last couple of minutes is justiciability. And so I've done some research on attempts to enforce provisions of law like Section 502B of the Foreign Assistance Act. And often courts find that they're non-justiciable, meaning that it's not appropriate, essentially, in their view, for a court to rule on the issue. And so they don't even reach the merits of a case. We see this in a case called Clark versus the United States in 1983, when Quakers sue for the use of their taxes to provide military support to El Salvador and Nicaragua. They say that that's in violation of Section 502B, and they are found not to have standing because their sole source of standing is as taxpayers. The last thing I'll touch on is the political question doctrine. And I think that this is one of the places where one of the things that we see come up most often in non-enforcement of foreign policy issues and of some of these standards I've talked about today. I think that Valentina being on probably means that I'm out of time. And so I'll wrap this up in a quick sentence, which is that often whether it is in cases regarding Israel or Yemen. The courts have found that there is a non-justiciable political question that they shouldn't weigh in, essentially. There are strong arguments against this, but this has been a barrier to enforcement of the standards that I've discussed. And it also opens the door to the importance of congressional oversight, which is often where courts have said that litigants should turn instead to the political process. So could go on for a long time. I will not, and I apologize for missing the remarks of my co-panelists at the beginning. I'm sure that they have very valuable reflections on much that I've talked about, but I'm happy to answer questions. Thanks.
Thanks, John. We'll come back to you in a minute, indeed. Before turning to questions from the participants, I'd like to come back to Shahid and Katie with a chance to both respond to and enter into conversation with anything that Frank and John said, and also perhaps to add a bit more, building on what you've said already, in reflection on what new opportunities and approaches to arms trade accountability are we seeing coming up from the moment around Israel and Palestine, and what are their prospects? Also, if you're able to offer, how do these build on the experience that we've had of the Arms Trade Treaty and litigation on and around it in relation to the Yemen conflict and some other situations? Maybe, Shahid, we can start with you, and you could also speak to the first challenge that we have post the entry into force of the Arms Trade Treaty in Australia, which is a novelty in a sense, and maybe also you could say a word about the provisional measures being sought before the Inter-American Commission on Human Rights.
Thank you for that, Valentina. So as you know, so there is history of that we're trying to continue, and perhaps that the extremity of the context of which we speak is actually a way to even push the legal framework forward. And I always say we can use Palestine as a critical way to move things forward. So there are multiple cases that are currently ongoing. In relation to the ongoing case in Australia, what happened is in that case, there was a case for preliminary discovery at the federal court on behalf of Al-Mizan, Al-Haq, and PCHR to gain greater transparency over the permits issued by the Australian government to Israel. We have information that says that there are multiple corporations that given munitions, specifically 105 millimeter shells, and 50% of the production is supposed to go abroad. So we don't, the main issue here is that we don't have enough information to say that for sure these weapons are going to Israel specific, and the Australian government has multiple times said that they do not, that they haven't given any weapons that are I'm trying to remember exactly the wording that they used, but more like destructive weapons. So they've used the wording to Israel. So they've used the wording to kind of limit the scope of what types of weapons could have been exported. Sadly, the case has not been continued. It has been discontinued, and the reason for which is confidential. However, what I was given the green light to share is that there is generally political unwillingness on transparency, and and also what we're currently looking for is further information. So of course, we're looking very like if the case goes ahead with relation to provisional measures, then the legal case itself becomes stronger, opening up the premises for asking the court again and asking for another request for preliminary discovery. If I may also reflect on Norway as well. So at the moment, activists in Norway are looking into their legal options. Information that they have now doesn't indicate that the corporations that they're looking at are complicit to the point of war crimes or crimes against humanity. But again, this would change with the change of the international legal scene. Because most of the chains that we have are indirect via the US. So most weapons from Norway are going through the US, and a good part of them were supplied prior to October 7th. However, there are other avenues which include advocacy and legal action to get the government to strengthen the applicability of export control laws and business and human rights law. There's also ongoing efforts in Italy. Also lawyers are looking into a civil suit for an indefinite injunction of arms exports. Last but not least, the Inter-American Commission on Human Rights. So there's currently, those are still, again, in preliminary stages, and there is a collaboration by multiple actors, including Latin American actors, to go first towards the Inter-American Commission on Human Rights. So the court previously has made it clear that it has the power to adjudicate over human rights violations committed by executives of corporations, and the court has also reaffirmed that to state representatives that they have an obligation to investigate and prosecute those responsible for criminal activities that are taken forward by courts, by companies. So at the moment, these efforts to draft the petition are ongoing, and hopefully after a decision from the commission, which is usually, as far as I understand it, the commission would seek to explore friendly settlement. If that doesn't work, we go to the court, the Inter-American Court for Human Rights, that does have jurisdiction over corporations. So that is one of the most promising avenues of litigation in relation to regional measures. But again, we're still looking towards, let's say, two things, which are the strengthening of the international legal position through General Assembly resolutions and the International Court of Justice's decisions, as well as the opportunity to gain further access to the ground, which is, of course, Israel's legal obligation, and hopefully further efforts will come with time.
Thanks, Shahid. Katie, there's also a question around whether we're seeing new trends around the accountability of government officials for violations of domestic law and the links between the US case and legal advocacy efforts at the international level. Maybe you could speak to that for now.
Sure. Just a couple of quick reactions, including that question. And I just want to say it's snowing very heavily here. And I got to notice that my internet is responding. So if you can't hear me, just please interrupt me and I will stop. But maybe first to just pick up where John left off, and that was around the political question doctrine, this idea that some cases can't be litigated in a court. That is the prime defense that the Biden administration officials have raised in connection with our case to enjoin their complicity in genocide and failure to prevent genocide. And we have responded to that in briefing, and we'll certainly be arguing this next week, where we say, when you're talking about unlawful conduct and complicity in genocide, those are prohibited under US criminal law. And the United States has recognized that both of these obligations exist under international law and are binding on the United States. The US recognized that last year when the Biden administration weighed in at the International Court of Justice in the Ukraine v. Russia case, where the United States recognized that duty to prevent is an erga omnes obligation. It's one that is binding on everyone. It can't be breached. So what we are saying is you can't have a policy decision to support a genocide. Your only position has to be to comply with the law, to prevent, to take active measures to prevent, not further a genocide. So we are asking the court to do what other courts have pre-ruled and find that when you're talking about a clear statutory or constitutional right that is being violated, that can't be a political question. That is a matter for the courts to adjudicate. And so the judge in California rules, and as other judges have in other cases, including cases against private military contractors and against corporations. So these are not discretionary policy decisions. These are not run-of-the-mill decisions about how much foreign aid to give. These are actions which are being taken with knowledge of how weapons are being used and continuing to make the decision to send that military support and assistance. And so whether it's Joe Biden, Boeing, the obligations are the same with liability for aiding and abetting, whether it's war crimes, crimes against humanity, or of course, as we are arguing, genocide. When a company or an individual, including, we argue, a government actor, acts with knowledge of how their practical assistance that has a substantial effect on the commission of a violation, when they have knowledge that it's being used to breach international principles, they have liability, and courts can, must, and can, should, and must act. So that is just an overall context, and I think we will be seeing that second wave of cases soon enough in the United States against companies who are acting with knowledge. So any weapons that they provided, especially after October 8th, October 7th, after Israel has made clear its intentions to really destroy in whole or in part the Palestinian people. And then we see day after day, week after week, month after month, the killing of civilians, the siege against civilians. There is liability there. I saw a question about Josh Paul, who is a State Department official who resigned. Josh Paul actually put a declaration in our case on December 29th, and you can find that declaration along with really powerful and frankly heartbreaking declarations by our plaintiffs that were also filed on December 29th. If you go to ccrjustice.org and look for Defense for Children International Palestine v. Biden, you will find all of the pleadings. But what is notable there, Josh Paul lists out the number of artillery rounds, the air-to-ground munitions that have been supplied by the United States since October 7th. Again, once that knowledge element was there, and he identifies that the support is not limited to fighter jets, attack helicopters, and various munitions, including 155 millimeter artillery shells, JDAMs, MK-84 bombs, Hellfire missiles, and tank ammunitions. I mean, these are just some of the ways that the U.S. is providing support, again, on top of its previous support. And he concludes, it would be impossible for Israel to have conducted the past 2 months of military operations as it has without utilizing a vast amount of U.S. origin weaponry. So I think when you look at the United States, whether you look at U.S. officials, or whether you look at the corporations who have worked with the United States and worked directly with Israel to continue the flow of weapons, you know, we look at the ceasefire, the pause, and that was an opportunity also to rearm. All of these actors have liability when they know how these weapons are being used. And another declaration in our case, already filed the first week of November, was from William Schabas, who, Bill Schabas, as many of you know, is a kind of the expert on genocide around the world. And in the declaration in our case, he found already back in the first week of November that the US was in breach of its obligation to prevent genocide. So there is notice, there is knowledge, and unfortunately, tragically, there are results on the ground in terms of lives lost, lives destroyed, civilian infrastructure destroyed, medical facilities bombed, thousands and thousands, tens of thousands of people who are injured at this moment, who can't get support and assistance, and millions who are displaced. So there is knowledge, there is action, and there has to be liability to stop reoccurrence.
Thanks, Katie. I'm aware of time, so we might want to switch on to the Q&A. And Jeff, maybe you could come on to help a little bit with the tech, because we do have an option of getting some of the audience who might want to speak to their questions to do so. Not sure how. You're muted.
Yeah, thanks so much. And thanks everyone, all the panelists so far. Yeah, Valentina, if there's someone who you see you would like to give the chance to speak, just let me know and I can turn on allow them to speak. So if Valentina turns to audience members that have indicated a desire to speak or is looking at a question that you've asked, if you want to speak it, I will turn on your microphone and you can jump in then if you'd like.
Okay. We might want to do that consensually. So if we don't hear from folks somehow, maybe further in the questions or in the chat, then I will just proceed to read some of the questions. Maybe I can take them in batches. Some of them are clarification questions, so I would invite, maybe I'll take those last, and maybe each of our panelists can also have a quick look if you want to pick up those clarification questions in your answers to some of the more substantive questions, or just type your answers in there, because there's some very specific questions about submissions and about broadcasting. So I think maybe we can start with the group of questions, and I may not pick all of them up together, on the ICJ proceedings. And Shahid, it would seem that you could speak to those in particular. Of course, there's Martin Butcher's question around a submission by an NGO. If you might want to say a word on that, if that's possible, and how civil society might be participating in those proceedings more broadly, perhaps even beyond the technical aspect. There's a further question from Sam Perler-Freeman that's pretty substantive, and I wonder if Sam might want to speak to it, actually, but I'm not sure how to know if that's the case or not.
Let me maybe quickly turn on Sam's audio to see if you'd like to jump in. And Sam, if you could quickly speak your question, that's great, but maybe we can start there and turn it over to the panelists. So I'm going to enable you to talk if you'd like. Sam, I believe I just did.
Okay, can you hear me?
Yes.
Right. So my question is, if the ICJ implements provisional measures, which, as I understand it, would mean that they were saying that there's a risk of genocide, could there be a case for the UK and EU states to be required to stop arms export licenses for anything to Israel, for anything that could be used in Gaza, under the criterion 1 in respectively the UK's arms export criteria and the EU common position, which are very similar, and those relate to states' international obligations. So they list a load of specific treaties like non-proliferation, arms embargoes, and other measures like Wassenaar Agreement arrangement, but they also include other international obligations. So if there's an ICJ ruling which says there's a risk of genocide, could one argue that exporting military equipment for possible use in Gaza would violate obligations under the Genocide Convention not to cooperate in the potentially genocidal acts? And thus, usually these cases in the EU, we've used criterion 2C on risk of IHL violations, but could this then take it up to criterion 1 on the UK stroke any EU member states' international obligation?
Thanks, Sam. Before turning to you, Shahid, and indeed anyone else who wants to weigh in on this, there's also Mary Jane Freeman's question, clarification in relation to the ICJ Feb pleadings. So maybe we can start with you, Shahid.
Well, first of all, in relation to NGOs submitting at this point, the only two parties who are able to converse with the court are South Africa and Israel. So I've been seeing a lot of things going around the internet saying, talking about that, but sadly that is not a possibility. There is a call to submit evidence by the International Criminal Court. That is only done through the website of the International Criminal Court. Otherwise, any support by civil society can be seen in the later point of the case. That is my understanding. If anyone else has any other different understanding. As per Sam's question, thank you for that. You're absolutely correct, and I absolutely agree with you. And I think this is the most logical way forward in the idea that, according to the ILC draft articles on state responsibility, the states in this case will have a very, very clear duty not to recognize, not to cooperate, as well as their duty on the Genocide Convention. So here we're talking to the level of state responsibility in relation to, as noted by Katie, violations of preemptory norms of international. So this is as high as state responsibility gets. And it's very much arguable on a judicial review level that by supplying arms to Israel, states would be in violation of their international duties as states. And this leads me on actually very well to the question in relation to the February case. The question there is about the illegality of Israeli occupation and the consequences of it. And the argument put forth by Palestine in this case is that the Israeli occupation of Palestine is in contravention to the Palestinian right of self-determination, the prohibition against annexation, and the prohibition against apartheid, three of which are, again, preemptory norms of international law. If we see a positive conclusion, and that would be an advisory opinion, so it wouldn't be binding. However, it would mark the Israeli occupation as a whole as a grave illegality, not just in relation to the ongoing hostilities in Gaza. And this would then also further facilitate, again, an enactment of what Sam kindly noted in this case. And if anything, the historical precedent we have with South Africa is very telling, because the moment the world recognized the illegality of the apartheid in South Africa, that facilitated a good deal of international legal activism, nationally and internationally, in order to kind of legally isolate South Africa. And then, of course, that legal isolation led to the change in the regime. And this is a little bit of a historical precedent that we hope to see in action in relation to Palestine. I hope that did justice to the questions.
Thanks, Shahid. Does anyone else want to weigh in on?
Thank you.
Maybe we can weave those in further questions. There's also a set of questions in relation to the U.S. proceedings or U.S. advocacy. Maybe Katie and John, you can take those up. One's from Ben Steele, who doesn't wish to speak, asking, my understanding is that our treaty obligations are tantamount to constitutional law. How does the U.S. handle the responsibilities under these rules? And can we expect to uphold responsibilities to IHL if the ICJ does find in favor of Palestine? There's another question on the U.S. Side. It would be great to know if the panelists can elaborate, this is from Mads Harlem, on anti-boycott legislation in the U.S. and how it will influence companies' arms sales to Israel. And then finally, to John specifically, are there any legislative initiatives now being considered to create enforcement, which is enforceable? Maybe Katie, you could start, and then John, you follow, if that's okay.
Sure. Maybe first on the first question about what these treaty obligations are. They are real. We tend to think of them as aspirational because they've been given such short shrift by administration after administration, too often including, irregardless of party. But what we heard President Biden say when he took over as president was that there was going to be a return to the rule of law. And it was actually Joe Biden, back as a senator in 1988, who finally, after 4 decades, helped to get the US to ratify the Genocide Convention. So look at what's happened over the last 101 days. We have a Biden administration that is definitely not preventing and is most strongly, arguably, furthering a genocide. I think it raises serious questions about the entire international legal order if the United States is allowed to just ignore its international obligations. And I think for me, that's part of why the cases that are happening elsewhere, whether it's at the Inter-American Commission or in the Netherlands or in Australia, or in South Africa itself, if not South Africa at the ICJ, are so important because we are at an inflection point. Is this international legal system that so many of us have felt, and our comrades, our colleagues, our plaintiffs that we've worked with to bring cases, whether it's around US torture or Israeli war crimes, or frankly, crimes by Russia in Ukraine, we've seen an international legal order that has not met the moment. But if we have a decision by the International Court of Justice, which again, the United States has affirmed as a legitimate body just last year in the Ukraine v. Russia proceedings, if we find the US wholly ignoring this, we have a real crisis in international law. And I think we will have to do that, whether it's new structures, new organs, or whether it's a pushback by those countries that profess to believe in democracy and the rule of law to demand that the US and Israel comply. And maybe this leads into the second question about anti-boycott legislation, which we've had a spate of around the United States at the state level. Boycott has historically been a means of popular resistance in the United States, and it is constitutionally protected. And the way that the boycotts, the efforts to divest, be it corporate or individual or state, and sanctions have been deemed almost as acts of terrorism when they are acts of resistance to an occupation. What we're going to be seeing at this moment is whether the duty to prevent and not further genocide is hopefully viewed as stronger than weak, false arguments about the silencing of dissent when activists are trying to effect change through peaceful boycotts. And let us hope that the obligations to prevent genocide, stop war crimes, stop crimes against humanity trump, and are viewed to trump politicized suppression of speech, which is what we've seen in the United States.
Thanks, Katie. John, would you like to?
Sure. Thank you, Valentina. Much appreciated. Yeah, first to completely echo Katie's remarks. I mean, the Supreme Court in the Paquete Habana case in 1900 acknowledged that international law is part of our law, part of US law. Treaties are on par with statutes as the supreme law of the land, federal statutes in the United States, rather, as the supreme law of the land. In the US legal framework, law and treaty are at equal level, with the Constitution being seen as above. That's different from understandings in international law of how domestic constitutions fit into the framework. We've often seen that the United States has used international legal institutions when it is advantageous to it, and avoided accountability when it is not. There's a law scholar who describes the United States as historically playing a role as a flying buttress to the international law and human rights institutions, trying to support from the outside without being subject on the inside. I agree that we're at a significant turning point where double standards are clear for all to see. And to move on to the question about legislative efforts to strengthen enforcement, certainly there have been often decades-long efforts to strengthen the legal mandates around arms transfers and security assistance that are enshrined in U.S. law. Sometimes that means moving from non-binding policy of the United States language to stronger shall language. In other instances, that has meant closing loopholes in implementation, which can take many years, unfortunately, for legislative change to occur. Currently, in light of the devastation in Gaza and tens of thousands of people killed by Israeli operations, we've seen the beginnings of congressional oversight efforts. Today, there will be a vote on a resolution introduced by Senator Bernie Sanders under Section 502B of the Foreign Assistance Act to try to exercise scrutiny on continued U.S. arms transfers and Israel's human rights practices. There are also attempts by Senator Van Hollen and Kane to have greater oversight and transparency when it comes to U.S. arms provided. But Congress moves slowly. It's a very difficult political situation. It shouldn't be, but it is for many members of Congress. And so, unfortunately, in many cases, what we'll see is too little too late for tens of thousands who have already died, and for generations who will be living the consequences of this war.
Thanks, John. Okay, we're left with a few minutes and two questions specifically to you, Frank. One from Maya Brem on the challenge against the F-35 program and the changes, the ongoing review of the EU common position. What changes would you recommend in light of that challenge? And then by Anna Nagrila, also to you, Frank, around the recommendatory nature of risk assessments after the granting of the permit, and how might we argue against that kind of textual interpretations that many states have indeed assumed. I would also add to that, just because we're short on time, but I know that others might also want to weigh in on Daphne Gnatio's question around challenges that go beyond states, challenges against arms companies and investors, and noting that Pax had a report on investors in the arms trade. So maybe, Frank, you can start us off with those three.
Yes, thanks, Valentina. And indeed, starting with the last one, we reckon that it is, and we experience that it's already difficult enough to challenge the government. And we know from past experience that challenging companies is even more difficult. And given the speed that we thought we had to act now, we decided to leave it with the government. But clearly, I think, and especially maybe in other jurisdictions, it may be very worthwhile to consider this, especially given the risks involved and the clear risks as we can all see them. Then I want to go first to the question by Anna Negrila that I think is basically included also in Maya's question, that yes, indeed, in the common position as well as in the Arms Trade Treaty, there is the encouragement that if new information comes to the state that has granted an export license, it's encouraged to reassess the export license. And in the court, the government lawyers have indeed said that, yeah, it says just encouragement, there's no obligation at all, and why would we do it? Which is really, really stupid, because they've done so in the past in many different situations. For example, in 2011, with the so-called Arab Spring, they've reassessed all the export licenses that were ongoing then to Egypt, to Bahrain, to Tunis, to Morocco, etc. And so, I mean, with the situation in Gaza so much worse, so much more challenging there, it cannot be seen as a voluntary encouragement. It's really something that I think should be understood to be much more compulsory. And then finally, on Maya's other question, also what are the takeaways of the ongoing review of the common position of the EU? This obviously should maybe deserve a little bit stronger language than just an encouragement. And the other thing is that we've seen now with the use of these general licenses, they basically don't fit in the export control systems as we know them, because there's no time constraint on the limit. They can last basically for the whole length of the F-35 program for the next 40 years. And it doesn't take into account any new customers that may also be a recipient of transfers from Dutch exporters. So clearly the case-by-case basis on which export assessment should be made is not applicable to the sort of general licenses that is in place, at least in the Netherlands, for the F-35. Thank you for your time, and thank you, Valentina. Back to you.
Thanks so much, Frank. I think we're wrapping up, so I will just say thank you to all of you for your time and for your incredible work, and the very best of luck to all of us in that. And also apologies to those few questions we didn't manage to cover, of course. I'm also meant to say to you that you will get a quick survey that will pop up when you exit that we very much would like you to quickly fill out if that's possible, and that there will also be a follow-up resources email in the coming days. Jeff, is there anything else you'd like to add before we close?
Nope, thanks a bunch, and thanks everybody. Thanks panelists, and thank you all for joining in on this. I know there's still much more to do and much more to follow up on, but really appreciate your attention.
Thank you.
you.
Thank you, everyone.
Thank you. Bye-bye.